So now, how will the defense team counter all of that data that came in on Monday? Let's talk about it. Let's bring in someone who was in the courtroom watching it all. The creator and the host of Road Patrol Live, John DePetro, is with us, and attorney Randolph Rice, former prosecutor as well. Great to have you both on this. So, John, let's start with the facts that were introduced and the new things that came in. What kind of a story was being painted yesterday morning in the courtroom?
Julie, the timing of this was perfect, simply because, number one, it was a Monday morning. All the jurors were fresh. I also want to point out the jury had just been at 34 Fairview on Friday, so now it really all made sense. But what Ian Whiffin did and Hank Brennan pulled out of him so brilliantly was, number one, the fact that John O'Keefe, his cell phone, never entered the house. It was right at the flagpole. And why that was significant, the jury was there on Friday. On top of that, the temperature of the phone. You know, the conspiracy was he was dragged inside the house. He testified that cell phone stayed outside and then was actually even warmed by his body, and then it dropped down again when they removed him. And then finally, the Google search, with Ian Whiffin basically saying there's no way that Google search happened at 2:27. It was a remarkable day for the prosecution, Julie Grant.
It really was. John DePetro, thank you for all of that. That PowerPoint presentation, too, that they put on, right? That was also something very different. And the evidence, as you said, John, so strong, which raises the question, how will the defense counter it? How should they counter it? Randolph, I want to go to you on that question, please.
Yeah, and I'll be the defense here for this argument, is that flagpole location really doesn't make any sense as to why he would be dropped off there and be struck there. In addition, remember, there's a lot of questions about Cellebrite and their consistency of the data. I'm sure the defense is going to bring into question how they have the problems with the Google search. Maybe they also have problems with the temperature.
That's a great point. You know, Randolph, something that really caused my ears to perk up, and John, I want to ask you about this because I know you caught this. When Ian Whiffin initially started giving his testimony, he mentioned the defense's cell phone expert, Richard Green. And we all remember the recent motions hearing where Hank Brennan destroyed him on that cross and essentially talked about how Cellebrite revised their program. They actually updated their software so that no one could do what Green did and make a mistake misinterpreting the case. But Ian Whiffin said that he reached out to Cellebrite for clarification. John, I'm curious if we're going to hear more about that today and your thoughts on that overall.
Julie, that was very significant because Richard Green and his Whiffin said then he didn't get back to him on it. So they had flagged that there was something wrong. People need to understand Richard Green was a witness that didn't perform great for the defense, but he was on the stand. And here you have, that's the first time we had heard that a defense witness had actually reached out to Ian Whiffin. But Julie, I can just tell you in the courtroom, this jury is actually built for type of technology. Just read into that. It'd be younger people as opposed to older people who may be a little more tech savvy. They were on the end of their seat. Ian Whiffin, with that British accent and the PowerPoint demonstration, he made it so easy to understand. I think the defense is going to have a tough time trying to cut into that.
Great points, John. Yeah, jurors expect technology. You're so right, John. Young ones, too. Something surely Hank Brennan knows. He teaches trial advocacy. And I want to go to you, Randolph, on another point that the state scored in clarifying something that the defense kind of made a mess out of last time. You know, they created a lot of confusion with John's health data from his phone, and they were trying to say that he was going up and down stairs. Let's take a listen to Ian Whiffin's explanation of why the phone registered that.
Do you have an opinion to a reasonable degree of scientific certainty whether the indication on the healthcare data reflecting flights of stairs, do you have an opinion whether or not that was registered as a result of a person holding a phone, walking upstairs, or for some other reason?
Based on the location data, the health data, and the research that I did and the testing, I believe it is more likely that the device was in a vehicle traveling on a road going up an incline versus the location data being incorrect and the person being walking up physical stairs.
Okay, Randolph, he's saying going up the hill caused that. Your thoughts, please.
Yeah, I find the defense, I'm focusing on two things. More likely, right? More likely is reasonable doubt. More likely is not, I'm certain that he is traveling in a car. And he really is uncertain of going up steps or in a car, riding up a hill. Why would that data be wrong? And that's something the defense really needs to lean into on cross-examination. More likely, reasonable doubt, stairs versus car just doesn't make sense.
Randolph, you're right. They're not going to be done with it. I'm sure they're not going to accept that explanation, and they're going to keep trying to push their theory. John DePetro, back to you, this timeline. One thing that it felt effective to me, but you could see the jurors' faces. When they went through minute by minute, they were able to account for every single minute from the time that John O'Keefe and defendant Karen Reed got in her car and drove to 34 Fairview from the last time his phone ever moved. I'm curious if you noticed any reactions from the jurors.
I did, Julie, and it was so easy to understand. It was kind of eerie. I was really also watching John's family, the O'Keefe family, as they were watching, the path of, I mean, that was John O'Keefe's phone. So it was almost, it's a part of him, and he was holding it. And they even showed where Karen Reed initially took a wrong turn and then doubled back. Watching the phone make its way to 34 Fairview, I thought it was emotional for the family. And just the way it was done was almost like a video game for the jury to kind of watch as they were winding their way right to an area that they had just visited on Friday. I found the PowerPoint presentation, Julie, very simple to understand, very easy to understand. And everyone that was there yesterday got a sense that that's exactly where it happened. And so this whole business of him going in the house, I think that's been knocked out.
I'm with you, John. I agree. I mean, the minute-by-minute accounting for. Now it's going to come time for the cross today for Ian Whiffin, as we know. And so what does the defense do with that? When we go through trials, a lot of times we'll say, oh, one side won the day, and then we'll see what the next day brings. Maybe the other side wins it. Randolph, in terms of the testimony from Ian Whiffin, I think anybody watching objectively would agree this was the Commonwealth's morning with all of that. It was pretty airtight. What does the defense do today when they get their chance to cross this expert?
Well, they've got to shred this witness. They really have just got to tear him apart, and they've got to show that the Cellebrite data is just not reliable, and that causes that reasonable doubt. They've got to win the day, as you just said. This has got to be their day on cross-examination to just destroy him. And remember, we're early in a possibly 6 to 8 week trial. Hopefully some of these facts fade in the minds of the jurors.
Sure, that's another thing, Randolph, the time, right? Primacy and recency. They've got to keep those reminders up if they're the Commonwealth. John DePetro, last question to you, please. The vibe in the courtroom, just any interesting observations? I know you have lots, and we'll continue watching your social media for them, but any impressions you walked away with yesterday after court was done?
Julie, I think the jury found this very, very compelling. And again, they were sitting forward. Later, as Robert Elise started to do it, he kept the lights down. And he has, nicest guy in the world, but has a tendency to drone on a little bit. I think right now the prosecution, they seem to be moving it along nicely. And as a matter of fact, the jury result of that, their engagement seems to be stronger.
That's a good sign. We want the jury interested and following all the facts. John DePetro, you're there, ready to go in, so we'll let you get going. We'll look forward to talking with you more later. Thank you kindly for everything this morning. And Randolph Rice is coming with us. I want you to do the same at home, please, when we...
Because she was out of control. My dad had been molesting me.
The key issue of exhibiting insight, full insight into their crimes and completely accepting responsibility for their actions. This is where the Menendezes, like Sirhan, also fall short.
The Menendez brothers' bid for freedom is what's trending in true crime this morning, but with a new twist as they're asking to disqualify the new district attorney, Nathan Hochman. What? So on Friday, the attorneys representing the convicted killers filed a motion citing a conflict of interest in the office, and they're pointing to the newly appointed director of victim services who once represented another family member, extended family member of the Menendez brothers, who opposed the resentencing. But The Menendez brothers are saying that the recusal of Nathan Hochman needs to happen, that it's only proper for a fair hearing. The motion says in part, quote, under the district attorney's view, there can be no rehabilitation unless defendants not only admit the shooting, but disclaim the corroborated history of sexual abuse, which caused the first juries to reach verdicts evenly split between murder and manslaughter. Defense attorney Mark Garagos is representing the brothers and doubled down on his claims after the last hearing was delayed.
Mr. Hochman taking positions and doing press stunts that, in my humble opinion, not only violate his duty to the law, but violate his duty to the state of California, the county of Los Angeles.
The next hearing set for May 9th. The question we're asking this morning, is the Menendez defense team just trying to antagonize Hochman? Let's bring in our power panel. With me this morning, attorney Randolph Rice and attorney Melba Pearson. Good morning to you both. All right, Melba, let me start with you. Your thoughts on what the defense is doing here?
Well, good morning, Julie and Randolph. And I don't think that it's a matter of antagonism. I think it's a matter of the fact that the defense felt that they were able to make great strides with the prior district attorney, George Gascon, and they thought there was literally a pathway for them to be released. He was all on board and wanted them out, and then he lost his election. So then DA Hochman came in and basically revoked any deals on the table and was like, you know, unless these criteria are met, I'm not going to agree to them being released. And so he's now vigorously fighting this resentencing and any idea of them being released in any way, shape, or form. So in the defense's view, they're seeing this almost like, I wouldn't say a breach of contract per se, but they're thinking he is very clearly against them. And by his public statements and his, assertions around this, that basically they're not going to get a fair hearing because they had it with Gascon. They now don't have it with Hochman, and Hochman is not honoring the deal that they had with Gascon. So I can see why they went down that route. Now, is it going to be effective? Separate story. But I can see why they filed that motion.
Yeah, and I appreciate what you're saying, Melba, right? How they felt like they made so much progress with the last DA. Now they feel like they're back to square one. Certainly understandable. They're advocating. Garagos, he's a great lawyer. Love Garagos. He's advocating. He's advocating for the clients. He's paid, to be the one making arguments for them that will best serve them. In terms of DA Hochman and his role in the office, I got to tell you, he came in so thoughtfully and didn't rush to judgment. I mean, just taking a step back, he said, I'm not going to take any position on this case. I'm going to take my time, go through, speak to people in the office, and do my homework. So I think, there is that to be said. Randolph, I saw you nodding there. Your thoughts on whether this move to disqualify him is proper, as the defense says?
Famous writer Carl Sandburg once said, if the law's against you, you argue the facts. And if the facts are against you, you argue the law. And if the law and the facts are both against you, you just bang on the table and scream like hell. And that's what they're doing here. They don't have the facts. They don't have the law. And what they're doing is they're going after the DA on a personal attack. And I don't think it's going to get very far because you've got to have a conflict, and there doesn't really seem to be a conflict here. There's no personal benefit for him to make these motions and to deny these motions of the Menendez brothers.
Right. I appreciate that, Randolph. When I was looking at this, I'm like, where's the conflict? So you have a woman who's got a career and a track record for advocating for victims, helping victims, and she gets appointed to that position in that huge office, but she's not directly involved in these decisions right here. Where's the conflict? I think it's a big stretch. That being said, these two brothers still are gaining support. It seems like the more the case lingers in the balance, more people are coming out. One of those celebrities who's been outspoken for a while now, Rosie O'Donnell, a big advocate for them. Here's what she said most recently.
Both Lyle and Eric have amazing prison records with what they've done with their time and how they've spent their 30-plus years in jail. So we believe them now because of Roy from Menudo? Do we believe now because of the letter that Eric sent his cousin 8 months before the murder? Yeah, it's time. I believe them.
So Do you? We're asking, how long will Hollywood be behind the Menendez brothers' bid for freedom? Oh, that's a good question. Randolph, I see the shake of the head. I'm going to start with you this time, my friend.
Well, unfortunately, Rosie O'Donnell, I'm not sure is still Hollywood, because if you remember, she actually moved to Ireland and became an Irish citizen. So she's not technically Hollywood anymore.
We stand corrected, Randolph.
But I will say
the Irish ambassador to Hollywood. Yeah.
I will say though that this is just very typical of Hollywood, is that when your career is sliding, that you maybe start to attach yourself to some sort of cause or issue and ultimately try to get your name in the press. And I think that's what Rosie is doing here. I really don't think she believes and probably doesn't even know the facts of the case, and just trying to get her name out there.
Right. Melba, to you next, please. Your thoughts on Hollywood being behind these guys?
I'm going to be the devil's advocate all day today.
Please.
That's just what's happening.
Atta girl. No, we love it. We love you, Melba.
But I think, love you too, but I think that this is not necessarily a matter of sliding careers or anything like that. Hollywood loves a good comeback story. That's the beginning, middle, of end of it. And again, when you see some of the movies and other made-for-TV series and all of that that has been done with this case, you know, it's showing people's perspective, and it may not include certain aspects that others would have wanted to be included in terms of talking about more of the more salacious facts or more of the things that the prosecution relied on in order for the jury to come to that verdict. So people are always going to take sides on this. Just like the viewers are divided on this, Hollywood is divided as well. And I'm sure there'll be folks in Hollywood that think that they should remain in prison for the rest of their lives. And I think there's others that think that they should be released. And Rosie O'Donnell's one of them. I mean, whatever her career status may be, but I'm sure there's others that are high profile, much more current, still getting roles, no issues, and they believe they should be released. I mean, just like anything else. You know?
Right. No, you're right, Melba. Everybody's entitled to an opinion. That court of public opinion is always in session. You both know, always in session. Great points. We'll leave it there for now. Melba Pearson, Randolph Rice, stay right there. We're going to hit a break. When we come back, here's what's coming up on Opening Statements. Welcome back. This morning, we're shining a spotlight on the young woman who stabbed her classmate to please the fictional character Slender Man. Her conditional release has now been put on hold. Defendant Morgan Geyser appearing in court Monday to finalize her move from a mental health facility into a group home. Problem is, the plan that was being proposed was to put her in a group home only 8 miles away from where her victim, Peyton Leutner, lives. Now, Geyser and another friend, Anissa Werner, stabbed Peyton Leutner 19 times back in 2014 as part of some Slender Man fantasy to please this fictional online character. Well, the victim's mother told the court that nobody bothered to speak to them about that proposed plan to move Geyser in the community and very close to where Peyton lives.
Peyton has worked incredibly hard to heal from the profound trauma she endured and has established a meaningful life within this community. She deserves the fundamental right to continue living her life in peace. She deserves the right to engage in everyday activities, such as grocery shopping or visiting the library, without the agonizing fear of encountering the individual who held her down and stabbed her 19 times when she was just 12 years old.
My God. So the judge ordered the plan to be modified, thank goodness for that, for everybody to return to court on June the 9th. How did nobody talk to the victim's family and know that this group home was going to be just miles from where this young woman is trying to rebuild her life? Let's bring in forensic psychiatrist Dr. Carol Lieberman and attorney Randolph Rice to talk about this. The judge expressed some frustration about the lack of communication here between the state agencies and between the court. Let's start by taking a listen together to that.
It's a secret, and unfortunately, the court can't be secret from the court. And it wasn't until this morning, and when it's brought up in the court on a number of occasions.
Okay, so how does this happen? Dr. Carroll, your reaction to this, that no one consulted with the victim's family?
This is such a poorly managed case. This woman has schizophrenia, childhood schizophrenia, a very serious case, hallucinations, delusions, thinking she was different animals, all kinds of things, not to mention the fact that she stabbed her friend 19 times. And now, I've treated countless people with schizophrenic in a psychiatric hospital, out of the hospital. You can't cure schizophrenia, but you can treat it and manage it kind of like diabetes. You can keep it at bay, so to speak. You can keep the major symptoms at bay. But that is not what has been happening with her. I have been on the edge of my seat watching these hearings, hoping that they don't let her out. She has an accident waiting to happen. She hasn't been on medications for a long time, which is wrong. Schizophrenics do need to be on medication all the time. You can maybe sometimes less amount than other times. But the idea that they picked something that was 8 miles away from the victim is just a sort of a peek into the mismanagement that has been going on all of these years, which is so sad, because theoretically she should be in much better shape right now than she is. The last time they asked for her to be able to, she asked for it to be able to leave. The judge said yes, and then they brought up the idea of how she's been talking to this man outside of the prison, and he's visited her 3 times, and he seems to be, she's gave him drawings and so on that he's selling on the internet. It's a very bizarre relationship. She was reading this book called Rent Boy that she didn't tell anyone about. Eventually they found out about it. So much is going on that is wrong. It's like, who's minding the store? She's not getting the proper treatment, so she is absolutely not ready to get out.
Dr. Carroll, preach. I love everything you just said. I was stunned, quite frankly, I was stunned when the court made the decision to conditionally release her. And so I really appreciate your points as a forensic psychiatrist about how going back to that decision, it may not be the right one. Randolph Rice, I'd love for you to put on your prosecutor's hat. You were a prosecutor on very serious cases for a long, long time, headed up the gang unit in your former office. When we think about the idea that this woman could be a danger to society, I'm curious if you think whether these prosecutors could be a bit nervous about trying to reintegrate her into community life.
Well, I'm a little shocked the prosecutors didn't catch this early on, and maybe they did, and that's why they're obviously having this rehearing to sort of figure out why she would be moving 8 miles away from the victim. But putting on the hat of Morgan Geyser's defense attorneys, at some point she's got to be reintegrated, and there's got to be some progress. There's punishment stages, and there's obviously the rehabilitation. And so they've got to get her back into society. Maybe the group home is that attempt to do that so that she can be controlled. The 8 miles certainly is concerning. But as a defense attorney, I would say, look, we've got to try to start moving towards the path of getting her back into society.
Randolph, appreciate that, the points, from the defense perspective as well. Speaking of which, the judge noted something about her clothing and makes you wonder if whether her attorney didn't communicate this to her. Let's take a listen.
I had authorized that she could wear civilian attire.
Oh, okay.
You didn't know that?
They didn't say anything. I apologize.
Really? Well, your attorney knew. It was in the court file. Well, good luck. Have a good day then, everybody.
Okay. Randolph, what do you think there?
Yeah, that's kind of consistent with the attorney not knowing that this was maybe 8 miles away from the victim's house. Maybe the attorney didn't know that she was able to wear street clothes. I'm a little worried that her attorney is not really doing, I don't like to second guess or armchair quarterback people, but maybe they're not really paying attention to the details here, and the details are what matters to these judges.
Exactly, Randolph. Well said. And this is one of those cases that needs to be handled with the utmost care. As you noted earlier, Dr. Carroll, this is a young woman suffering from something very serious. And if she isn't properly handled, the last thing we want is a repeat of what happened to Peyton Leutner. Dr. Carroll, how do you think this could best be handled? If you could provide a recommendation to the court on the best place for Morgan Geyser, what would that be?
Well, first of all, I would start with her getting better psychiatric treatment while she's in this hospital. Something needs to change. She needs more intensive treatment. I don't know what she's getting, whether she's getting just, whether they're doing anything for her in terms of therapy, whether she's getting enough individual therapy, whatever it is, she's not getting enough to get her better enough to be able to go out. She was given 40 years to life. And I agree that in the best possible world, it would be nice if she could get out at some point, but not when she's not ready. She is I believe absolutely that she's still a danger to society.
Excellent points. Oh, go ahead, please, Dr.
I would start with that.
Start with that she's a danger.
Well, start with the fact that she needs better, more intensive therapy, and then consider what kinds of things. The plan was, they were saying that, she's going to have an ankle bracelet, or she's not supposed to leave the house. I mean, not supposed to, but that wouldn't be able to control her. And besides, if she's not on medication, she needs to be on medication when she leaves the hospital. That's for sure also.
Right, treating the root cause. And I appreciate that, Dr. Carroll, because, right, if we're not treating her and the illness that she suffers from, then who knows what can happen. And you're right, an ankle bracelet certainly isn't foolproof. We all know that. We've got to leave it there for now, but great discussion. Dr. Carol Lieberman and Randolph Rice, thank you both for your time and your expertise on this. Still to